Hello, welcome everyone. Welcome back to another episode of Empowered Esquire TV, A Real Lawyer Reacts. So, you all know that this R. Kelly trial has been ongoing, right? And that he's facing prosecution in several different jurisdictions, which means this is an ongoing case. And similar to the Ronnie O'Neal case, it is a great opportunity for us on this channel to follow the trial, follow this case, learn a lot about the law, but more importantly, learn a lot about prosecution and how prosecution works. So today I have a special guest. I have Miss Diva Divine Light with me. Some of you may know her from her R. Kelly commentary here on YouTube. She has a YouTube channel, which we're about to take a look at. But I just want to take a moment to say that she truly is, just a phenomenal person. You know, she found me here on YouTube and reached out to me and has always been so encouraging and so supportive and just a really, really good person. And I know that she's experienced a lot of challenges, being online. And when you put yourself out there, sometimes, you meet tremendous pushback. And I just wanted to take the time to let her know that I appreciate her. I see what she's doing. I know she has good intentions. And I really hope that she's not discouraged, by anything that she's been experiencing. So, Diva, would you like to introduce yourself?
Hey, everybody. Yes, Miss Esquire, thank you so much for that. I appreciate you. And I'm glad I stumbled upon you by one of my moderators. Let me see a transcript. I really appreciate you. Shout out to you, sis. And you've been doing wonderful things for me and my team over there in the R. Kelly sector. We've learned a lot from you. And, from the bottom of my heart, I appreciate everything. And your wisdom is awesome. And yes, unfortunately, talking about R. Kelly, when you talk about celebrities, sometimes there's a lot of backlash and bullying and all types of things that go on. You just have to, thank you so much, by the way, Miss Esquire, for encouraging me and everyone else who has sent me messages throughout this week, because I've been going through a little rough week this week myself. And I'm ready. I'm ready for this trial. I want to go back and have my head focused, forget about the other things that are going on around me. It is what it is. And let's get R. Kelly convicted. Hey, everyone in the chat, by the way.
So with that being said, yes, a quick hello to everyone in the chat. I'll do my little shout outs in a minute. But first, for the next couple minutes, we're going to get an introduction to Miss Diva Divine Light. We're going to play a little snippet of my last visit on her channel where we discussed some of the ongoing motions in limine. Now, if you are unfamiliar with what a motion in limine is, it is an evidentiary motion. So it is a motion that is filed by either party, so either the prosecution or the defense, in which they say to the court, listen, there is a certain piece of evidence or pieces of evidence which we want you to rule on. We want you to tell us whether or not it should be admitted in court. And of course, they're arguing either for that evidence or against that evidence. So we'll play a couple minutes of that, and then we'll come back and we will take a look at the actual transcript from the pre-trial conference in this R. Kelly trial. We will hear from one of R. Kelly's former attorneys about his opinion as to what's going on in this trial and what we could see happen. And then, of course, we'll have a discussion about it and I'll take some questions. So let's dive right in.
Predisposition is not admissible except in 3 narrow circumstances. Now, Miss Esquire, what does all that mean?
So in other words, if someone is being charged with sexually assaulting someone, the victim's past, as far as their past lovers, their past sexual behaviors, things like that, that is not permitted to be allowed into the case unless you meet the exception which they're about to refer to.
Okay. And that is the federal R Evidence 412A Rule 412 aims to safeguard the alleged victim against the invasion of privacy potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. All right, now what does that mean?
So I think the last time I was on your channel, I mentioned to everyone that the federal government can be flexible with the statute of limitations when it comes to sex crimes. So as part of their policy to encourage, just as they were saying, to encourage victims to come forward, the federal government has done a number of things that are really unique only to these types of cases. So one of those things is that they gave themselves flexibility with the statute of limitations. They can be flexible on that. That is partially why they are permitted to bring the Aaliyah accusations into his current charges. But also what they're saying is whenever it comes to these types of cases, we want to encourage victims to come forward. And that is part of the reason that we are also creating this rule, which says in general, you're not permitted to talk about their sexual history. If you think about it from a common sense perspective, what a lot of criminal defense attorneys used to do is they used to just insinuate that the victim is promiscuous or insinuate that the victim is a prostitute. And they would use that to try to hurt the credibility of the victim.
Right.
So that is part of the reason why the government has created this rule, which says, no, we don't want to hear about that. We don't want to hear about whether or not they have a lot of sexual partners. We don't want to hear about what they do in their free time because their history is not relevant and it's only being used to intimidate them. So you would find that women who did have quote unquote active sexual histories, they wouldn't report being abused because they would say, well, you know, they're going to talk about my history and I'm embarrassed. So this entire rule was created to protect the victim from feeling that they can't come forward because their history is going to be on the table for discussion.
Interesting. I wonder, I wonder if the judge is going to let this rock. What do you think?
You know, I think that for the most part, especially because a lot of these women were allegedly minors when the conduct began, I think for the most part, the judge is going to say, you know, I don't want to hear about their outside romantic or intimate relationships for the most part, unless it is directly linked to these accusations. So, for example, the accusations that R. Kelly would make or would coerce the girls and women into doing other things with other people, well, then that makes those other actions with other people relevant. But other than that, I don't think the judge will allow this kind of broad conversation about their intimate histories.
Right. So it doesn't matter if the girls had sex with him and they weren't virgins. In other words, that's not going to be relevant.
That is
to the
totally
kids.
irrelevant. Yeah, that's totally irrelevant.
Okay. So let's get that out the way. You know who you...
All righty. So just a brief introduction to Diva's channel, to, you know, the amazing work that she's doing over there, and also, you know, to some of our meeting points and meeting times when I'm over there on her channel having these conversations as well. So I'm going to take this moment to go ahead and do my chat shout outs. Hi, Crime Spotter. Hi, K Business Podcast. Hello, Michelle Jordan. Hello, some of Diva's people are in the building. Hi, Johnny Davis. Hi, Aisha Stockton. Hello, Indigo Forever. Hello, Nikel Lee. Hello, Chanel Lewis. Let's see. Hello, Spiritual Gangsta. I like that name. Hello, Tarsha. Let's see. And hello to Flawless Beauty as well. If you're in the building, you can give a little heart in the chat if you'd like a shout out. And Diva, is there anything that you'd like to say before we hop into this pre-trial conference transcript?
Convict R. Kelly 2021.
So I have to say, you know, as Phyliciadcpearson Esquire, that the opinion of Diva Divine Light, while she is a wonderful person, is not necessarily my opinion or the opinion of Empowered Esquire TV. Alrighty, so we're going to dive into the transcript of the pretrial conference, everyone. It's a very, very interesting read. I'll tell you what, all of the defense attorneys are there. The prosecution is, of course, there. And we finally have a judge ruling on the motions in limine. So we have the judge saying, for this piece of evidence, here is my ruling. For that piece of evidence, here is my ruling. So after all the back and forth, and let me tell you, if you're not following the R. Kelly trial sector, I'm sure Diva can tell you, there's a lot of back and forth. There was so much contention about these motions, and a lot of people had very strong opinions. So all of that has finally amounted to the judge handing down these rulings. I'm not going to spoil it for you by telling you the gist of it, right? We'll go through it, and then I'll tell you my humble opinion. But honestly, by the time we go through the transcript, I think you'll be able to see the writing on the wall as far as, you know, what side of this trial comes out looking kind of sort of triumphant after this pre-trial conference. Diva, anything before we hop into the transcript?
Well, as she said, you know, there's a lot. It's you know, it's more than just the paperwork, because there's a lot of things that are floating around on the internet that people of his team members, his camp, have had plenty of interviews with many bloggers. And this trial is really, really, truly a circus. And in an interview that his ex-lawyer Greenberg had, he was questioned. So on a scale of 1 to 10, how hard is this case to fight? And you know what Greenberg said? He said 12. That's how hard this case is to fight. That's why I think he gave up. Wow. He gave up. You know, I think he's trying, you know, since he's like a showboat kind of lawyer, I think he wants to win. And he's trying to get R. Kelly to do whatever. And R. Kelly, I think, was just being uncooperative, you know, so he was done with him.
Wow. Well, for him to admit that this is a challenging case kind of already tells us what could potentially be ahead, because he's privy to a lot of things that we as the general public aren't, right?
Right.
Interesting. All righty. So here we go. We're looking at the pre-trial conference transcript here. Let me get into it. And so right here on the first page, as we've discussed, and I see K Business has already latched onto it. He's already picking it up. This is a federal case, right? So, you know, you see United States District Court. So the United States of America v. Robert Sylvester Kelly. That's how we know we're dealing with a federal case. So we're just going to look at which parties were present and when this happened. So this occurred on August 3rd, 2021 at 11 a.m. And we see this is the transcript of the pretrial conference before the Honorable Anne M. Donnelly. So if you haven't been following this trial, she is the trial judge for this particular case, Anne M. Donnelly. You can give her a Google if you like, kind of get a feel for her style. Quick teaching moment. Different judges have different styles when it comes to how they view the law, right? There are some judges that believe that they have the flexibility to interpret the law as they see fit. But then there are other judges who believe in what is called strict interpretation. So they believe, you know what, it's not really my role to have my own interpretation. I'm going to stick to whatever the law says. And if I'm really lost, whatever previous cases have said. One of the Supreme Court justices who was famous for being someone who said, hey, listen, judges should be strictly interpreting the law was Justice Scalia. May he rest in peace. But he was famous for saying that. He was famous for saying that he believes that we have gotten to a place where judges are being too liberal with their, you know, interpretations of the law. Okay. So anyway, nerd moment.
What's going on that they say that she's actually one of the top judges that run by the book. She runs by the book. She's a great judge that runs by the book. She knows the law. She goes by the law. She don't play no games in her courtroom.
Good to know. Good to know. So Diva and I are going to kind of give you the introduction into this transcript before we jump into what evidence it was actually admitted and what evidence was found to be inadmissible. I've actually gone through this transcript and highlighted for us each piece of evidence. So Diva and I are going to read pages 1 through 7, I believe is what we said, or 1 through 10. I think we said 1 through 10.
Yeah.
And I'm going to be the court. She's going to be everyone else. And we're going to get an idea for how we got to where we are. So we know the government was present, right? We know that. And then on behalf of the defendant, we know that Canick was present, right? Devereaux L. Canick. We know that Farinella was present. I believe that Nicole Beck, yeah, there we go. Nicole Becker was also there. And it looks like Calvin Scholar was also there. Okay, so we know that the government had 3 ASAs there. They had Geddes, Melendez, and Shihata. And then we know that pretty much the entire Kelly defense team was present. Okay. So Diva and I are going to start our reading here on page 3. So here I am at line 2. Everybody can have a seat.
This is criminal cause for a pretrial conference docket number 15 CR 286 USA versus Robert Kelly. Counsel, state your appearance. Government first. Ms. Geddes, Elizabeth Geddes, Nadia Shihata, and Maria Cruz Melendez for the government. Good morning, Your Honor.
Good morning.
Mr. Canick, for Mr. Kelly. Devereaux Canick, along with Nicole Blank Becker, who is appearing remotely, Thomas Farinella, and Calvin Scholar. Good morning, Your Honor.
Good morning, Mr. Scholar. Welcome aboard.
Good morning, Your Honor.
A couple of things to take care of today. I'm just going to remind you before we go into the motions in limine. Let me first ask Ms. Becker, are you staying with us on the case?
Thank you, Judge. Judge, I did. And I hope you received a letter this morning.
Yes.
From the doctor?
Yes.
Did you get that, Judge?
Yes.
Okay, great. Yes, Judge. Based on the doctor's assessment, as of today, I am allowed to travel. So I will absolutely be there.
Okay, great. All right. Second thing, jurors have been, so just related to what Ms. Becker said, I take it you're no longer requesting an adjournment. Is that right?
We're up and ready to go, Your Honor.
Okay, good. The second thing is that I'm sure you're all aware that jurors have been filling out questionnaires. And so as I directed earlier, we need to have your list on those jurors upon whom you agree, the ones that you agree should be excused. We need to have those tomorrow. So the ones you agree should be questioned and the ones that you agree should be excused. And then I'm sure there will be some that fall in the middle. We have to have that by tomorrow. Just in terms of the trial schedule, it's my plan to take Fridays off, except for those weeks where we have holidays. We have a number of holidays in September, religious holidays. And so the weeks that include a religious holiday will work on the Friday that day. And I don't have them at my fingertips, but I think they're pretty easy to find. Okay?
Your Honor, to be clear, the Friday before Labor Day, we're off.
Would you like to be?
Yes.
Well, I don't think there's anything else that week.
All right.
So yes.
I apologize. I'm Blank Becker. I apologize, Judge. I can't hear Mr. Canick speaking. I can't hear him.
Okay, just let's be mindful.
Sorry.
That's okay. Just be mindful of the microphone. Mr. Canick was asking if we had the Friday before Labor Day, and I don't think there's any other holiday that falls then. So the answer is yes. So we'll have that.
Ms. Geddes, and Your Honor, I'm sorry to interrupt.
That's okay.
Will you also sit on August 20th, since we have a short week that first week, Friday the 20th?
Is it a Friday?
Yes.
I think it's a good idea to make as much use of our time as we can. So yes.
Thank you.
Okay. Now I just want to go through the various motions in limine. Some of, at least with respect to some of the submissions, are under seal. And so I'm just reminding the parties to be sensitive to that. I'm going to begin with the government's motion to admit various acts that are not charged in the indictment, but that the government asserts are evidence of the pattern of racketeering. And just as a reminder, the time frame for the pattern of racketeering is from 1994 to present. Mr. Farinella, in your objection, there were just a couple things I want to clarify, because you're saying that you had insufficient notice under 404B. I mean, that applies to when the government is just seeking to admit evidence of bad acts, which is really not what they're seeking in this case. But you've had the discovery material and 3500 material for quite some time, which includes the materials to which the government refers. You're not saying you didn't get the material, are you? Diva, Mr. Farinella?
Oh, I'm sorry. I didn't realize I was muted. I was talking this whole time. Sorry, guys. Okay, I'm Mr. Farinella. Your Honor, what I've said in the motion is that the incidents that they are attempting to introduce into evidence, the 3500 material related to those specific incidents, were provided just recently.
February, I thought.
Well, there was an additional disclosure made on or about last week, this week, Monday, with additional 3500 material relating to these acts.
How many of them? All of them? I think you have to be specific. If you're claiming you were blindsided, which is what you said, so what specifically did you not get until recently?
Well, Your Honor, we only obtained the additional John and Jane Does, that information yesterday at the time.
Do you mean the names of them?
There's an additional 17 Jane Does, and there are 2 additional John Does.
I just want to make sure I know what we're talking about. I'll go through each one. But my recollection, and I actually checked the docket sheet before today's appearance, was that the representation by the defense was that you knew who all of the Jane Does were. Are you saying that's not accurate?
So, Your Honor, I'm not saying that's not accurate. That is in fact accurate.
Okay.
In the underlying indictment, Your Honor, there are 6 Jane Does. We've obtained the identity of those Jane Does. However, in the government's motions, they have unveiled 17 more additional Jane Does and 2 additional John Does. Oh my God, you hear me?
And are you saying that you didn't know the names of them until recently, or that you didn't have any information about the acts that are connected to them?
To the extent, your first question, Your Honor, the names were only revealed to us, the actual specific names as to each of the Jane and John Does was actually provided to us yesterday.
Okay, is that accurate? I want to ask the government.
Ms. Geddes, we provided a full disclosure of every name of the Jane and John Does yesterday. In addition, we had provided the names of several of those Jane and John Does previously, but we didn't identify them as John Doe or a Jane Doe because there wasn't a motion related to them. We just disclosed their names previously to defense counsel in the 3500 material.
What about the underlying acts?
The underlying acts were the subject of 3500 material disclosed in February, with the exception of, I'm looking at them right now. We did provide some additional 3500 with respect to Jane Doe 11 and 12, which we obtained after the initial February disclosures. So we provided that more recently.
Okay.
And we provided additional evidence of some of the other acts evidence that we seek to admit. But the 90% of what we seek to admit, we had previously disclosed the substance of those allegations in 3,500 disclosures and discovery disclosures.
So you acknowledge that, don't you, Mr. Farinella, that you had the substance of what these claims are?
Yeah, I mean, to the extent they were provided, yes, in the 3,500 material.
Okay. But that's what I'm trying to figure out. What are you saying that you didn't know about, that this is just a complete surprise to you? Anything, or is it just that there's additional? Okay, so the choices are, I never heard this before. I heard part of this before, but I didn't have all the facts in connection with it. Or I've heard the whole thing before.
She ain't playing with him. Mr. Farinella says, I think your second choice, Your Honor.
Okay.
I've heard it to the extent, but there was no connection to facts and to the actual witnesses themselves.
So you just didn't know the name of the person that was associated with the particular allegation.
Well,
you know, let's go through them all, because that's what I'm going to do anyway, and then you can tell me. The other thing I'll say about notice is that I'm the one who set the motion schedule for motions in limine. Mm-hmm. And the only thing I recall about that is that the defense asked for extra time, which I granted. So that was what the schedule was. And if there was some need to have it sooner, I'm sure you would have told me. All right. So what I'm going to do is just go through these. And if I miss one, because I did get a lot of submissions, I'm sure you'll let me know. So the first one has to do with the claims related to Jane Doe number 1. And these allegations are about conduct in 1994. The government's position is that this evidence is direct evidence of the enterprise, that it provides the motive for the charge in racketeering, for the conduct in Racketeering Act 1, and that is inextricably intertwined with that. And so it's clearly relevant. And it clearly shows a motive for Racketeering Act number 1, and so that is admissible. So pause for a second, you guys. We've gone through page 1 through 10 of this transcript, and as you can see, Judge Donnelly is spicy. Okay, she is not a wallflower judge. She's not a sit-by judge. She is very much into what's going on. She's active. She's read and reviewed everything. And it appears that Attorney Farinella has been making this argument of the government withholding evidence, the government withholding materials, not telling the defense team who the witnesses are. And if you're not new here, you know why he's doing that, right? And I think also the people from Diva's channel probably. But if you're a newbie here, let us tell you why he's doing that. He is setting up an appeal, right? Ow. He's setting up the argument that R. Kelly's constitutional rights were violated in some way. And if, again, like I said, if you're new here, there are certain pieces of evidence. Some jurisdictions refer to it as Brady, right? There are certain pieces of evidence that if the prosecution does not turn it over within a certain time, you don't even need to worry about an appeal because you have a mistrial. You have a dismissal right off the bat. So Farinella is already going for that. He's already using certain terms and saying evidence being withheld, and he's using all the buzzwords to try to set that up. But you see that Judge Donnelly is having none of that. Yeah. She pretty much, I set the schedule for disclosure. I told you when to disclose things, and the government disclosed things when I told them to. So you're not going to come in here and tell us that it wasn't disclosed within a timely manner, because I am the timely manner. Got it?
Exactly. She's not playing with him or his team.
What are your thoughts thus far?
Yeah, she's not. She's definitely spicy. I like her a lot. That's, in the R. Kelly sector, we call her Auntie Anne. She is not playing that. And I think, she sees the little games that they're playing. That's why she asks him in 20 different ways. You better not be saying what I think you're saying. So make sure you correct yourself, dot your I's, cross your T's before you try to say that the government's withholding stuff because then they could get in trouble for that. Correct, Ms. Pearson?
Absolutely. As we just discussed, Attorney Farinella, and truth be told, he's just doing his job, right? He's just doing his job.
Right, defending.
He's setting up a potential appeal. And if he can do even better than the appeal, like I said, if he can get some sort of mistrial or dismissal, he's going for that. So he's already setting up evidence being withheld and witnesses being withheld. But Judge Donnelly is not, she's not having it. She's not letting it happen. I'm going to take a second and say what's up to some people. Hello to the entire OCOV family. I honestly don't know what that stands for, but
one color, one voice.
I like that. All right. So hello, OCOV, to the whole fam. Hello. Hi, Karen J. Hi, Karen A. Let's see who else we got in the building. I think I said hi. Hi, Wings. Hi, Take R. Kelly. Let's see. I think everyone else in here is OCOV. OCOV is strong, huh? You guys are a strong fam. All right,
yes, ma'am.
So we're going to get back into the transcript. And what I've done now, so that we don't have to go through, because Diva will go through the entire transcript on her channel. So if you really just want to sit and listen to the entire transcript, you can get that on her channel. What I've done is highlighted all of the important moments as far as what evidence was admitted and what wasn't. So whenever you see pink, that is something that was in the favor of the government, right? Whether it was something deemed to be admissible or inadmissible. Whenever you see something blue, yes, go ahead.
Guys, so that means that Auntie Anne will be admitting the bribery charge with Aaliyah, which is Racketeering Act number 1. So that's what's being admissible. So those people on the other side saying that they threw it out, that's a lie.
All righty. So whenever you see the evidence highlighted in pink, you know that we're about to discuss something that was in the favor of the government. Whenever you see it highlighted in blue, it's something that was in the favor of the R. Kelly defense team. And whenever it's just a simple yellow highlight, you know that it's just a teaching moment. It's just a conversation that we're going to have for our own enrichment. And of course, I'll be stopping along the way for Diva to chime in. All right. Yes, so let's dive in. So our next piece of evidence comes up around page 16. Here we go. We're here. I'm going to start up here at line 1. Okay. So, well, actually, you know what? Let's go back to here. Here we go. So we are here on page 15 at line 18. The next request has to do with Jane Doe number 8 in 1994. Pause. Diva has already prefaced for you that it is believed that Jane Doe number 8 is who? Aaliyah. Okay. The next request has to do with Jane Doe number 8 in 1994. The government proffers Jane Doe number 8 was in a concert of the defendants and was directed.
No, number 1 is Aaliyah.
Oh, it's number 1. Okay. All right. So this is a different. Wow. Anyway, I'm not even going to go into
another girl. Yes.
Right. I'm not even going to go into how many Jane Does there are in this case. Wow.
This is another girl. Definitely another girl.
The next request has to do with Jane Doe number 8 in 1994. The government proffers Jane Doe number 8 was in a concert of the defendants and was directed to go backstage by the defendant's associates, and that the defendant then had sexual contact with her. As the government has proffered before, they represent that this is direct evidence of enterprise and its means and methods. This is an example, and maybe I don't have to repeat it, but this is really not propensity evidence. This is evidence that is offered to show the existence of the enterprise and the methods undertaken to perpetuate the evidence. So it is relevant, and it's not unduly prejudicial. It's no more inflammatory than the charged offenses, and so that one is admissible. So you guys,
okay.
What just happened there is that Farinella and the defense team tried to get an encounter from 1994 deemed to be inadmissible. Now, as Diva just told us, this is not Aaliyah. So what does that tell us? There's more than one Jane Doe from 1994 that he's being charged with. Wow. Yeah. They talk about the allegations, and then the judge gets into the legal stuff. So let's discuss the legal jargon. Judge Donnelly says it's not propensity evidence. So remember when we had that conversation about A prosecutor cannot say that because you did something yesterday, you've done it today. That is propensity evidence. So a prosecutor cannot say, you know, because R. Kelly did whatever he did, you know, on Monday, we know he did it on Friday. No, that is propensity evidence. And the judge is saying, you know, this is not propensity evidence. She's saying this is actually evidence that tends to show that there was an enterprise, which means this evidence is not relevant in regards to whether R. Kelly did something in the past, but rather it's relevant because you have allegedly someone who is plucking these girls out, right? Allegedly, and bringing these girls to R. Kelly. That is an enterprise. So you have Judge Donnelly saying, listen, this is relevant, not because of propensity, because of the allegation of there being an enterprise.
Now, Miss Esquire, can you, you know, this is a racketeering charge, right?
Mm-hmm.
So they usually charge, you know, for mafias of that nature and gang members and things of that, right? So they're trying to say that as an enterprise, he worked as like a mafia because he was the head CEO and had his commission and then his soldiers. Kind of.
Right. So the key term is organized crime. So when you're talking about a gang, you're talking about the mafia, the law looks at those types of criminal organizations as organized crime. And that is the allegation here. The allegation is that R. Kelly had allegedly an entire organized, a whole criminal organization, which purpose was to solicit girls that he would then allegedly abuse in a sexual manner. Now, side note, usually I don't use that word on this channel, but we started very, very early with using the word. So I figured, I mean, why play games now, right?
Right.
So the allegation is that there was a criminal organization. It was not just R. Kelly choosing these girls and then soliciting them. He had an entire setup, an entire scheme of people who would pluck girls for him and bring them to him for the purposes of allegedly having intimate contact with them.
Now, my other question would be, why do you think that, you know, because there's also the obstruction of justice case, right? And they are alleging that Daryl McDavid and Milton Brown were the managers, so they're part of the enterprise. I want to make sure that the people out there understand that why is R. Kelly the only one charged in the New York indictment under the racketeering law?
So what we are discussing in this case is the trial of R. Kelly, right? So just because you hear us discussing R. Kelly's prosecution does not mean that other co-conspirators were not prosecuted or have not already pled guilty to certain charges. We're discussing R. Kelly, yes, but that doesn't mean that no one else was charged.
Do you think that these other people that might be charged will like their indictments might be unsealed or of that, you know, because they usually seal indictments and collect evidence, stuff like that, and so they're ready to unseal it, correct?
Right. So these types of cases, the documents tend to be sealed because it involves minors and it involves, you know, really sensitive allegations and things like that. It could be unsealed. So, for example, if let's say some of these co-conspirators are testifying in this trial, which I believe that might be the case, right? Then it's possible that the documents pertaining to their case is going to be unsealed, because I'm almost certain the defense will say, you know, those documents should be unsealed.
Right. Right. I want to know, who are the other people that you're charging? You say he's an enterprise, but why is it only one man being charged? Right?
Right, right. And so as we've just discussed, R. Kelly is the person on trial in this trial. It does not mean that he is the only person that was charged. I'm going to say it again. R. Kelly is the person on trial in this trial. It does not mean that he is the only one that was charged. There are several things that could have happened. Co-conspirators could have pled guilty, and or co-conspirators could be having separate trials. Co-conspirators do not always have the same trial.
Okay, yeah, because Daryl McDavid and June Brown are in the obstruction case in Chicago. And then the three guys who were charged with intimidation on his behalf, allegedly, two of them pled guilty and one of them is going to trial.
Thank you for that update, Diva. So you see, per the information that Diva receives, it appears that the co-conspirators are moving along in their cases, right? So, you know, friendly reminder, you guys, when you go to trial, you're not always going to trial with whoever your alleged co-conspirators are. They may have their own thing going on for their charges. Okay?
Right, right.
All righty, so we are going to hop back into the transcript. I just want to quickly mention, when you see here at line 5 about this evidence not being unduly prejudicial, that is something we've also mentioned. Remember that evidence has to pass through the probative value, the prejudice standard. And so Judge Donnelly is saying, listen, this evidence isn't any worse. It isn't any more prejudicial than the actual charges themselves. So it meets that goalpost. All right, let's see here. Now we're on page 18 with yet another piece of evidence. All right, so I want to make sure that we know exactly what evidence we're discussing. So I think we're going to need to start here on page, what is this, 17, up here at line 12, okay? The next item refers to Jane Doe number 10 in 2001. This is similar or somewhat similar. It's related to the previous one, but it also, oh, that was a mistake on her part. This has to do with Jane Doe number 10 being recruited by an associate at a concert when Jane Doe was 16. And at some point, Jane Doe became concerned that an encounter with the defendant was filmed, and so that she reached a settlement with defendant on that matter. Now, this is not one of those things about which you didn't know, is it, Mr. Farinella? And then Mr. Farinella says that he's reviewing it, and they have a whole back and forth, right? And then Judge Donnelly says, so the question is, well, I don't think there's any question as to whether or not it is relevant, because it, again, is evidence of the enterprise and its means and methods in settlement. The fact that it was settled, I think, is evidence of the effort to perpetuate the existence of the enterprise, because were that made public, it would certainly have jeopardized the existence of the enterprise. She then says, so it is relevant. It is not unduly prejudicial because it is, like some of this other evidence, no more inflammatory than the charged offenses. So it is admissible.
Woo, another win, guys.
So here is what all of that means. If you go back to page 17, they tell a little story, right? A little allegation of a Jane Doe who was about 16 being picked again by an R. Kelly associate. So when you hear Judge Donnelly saying it's relevant because it's proof of the enterprise, she's saying it's relevant because it's proof that they were working together. They were working in concert, allegedly, and it proves that, which makes it relevant. She then goes on to say that they eventually settled with this young lady. And she said that is relevant as well. She said that the settlement is proof that there could have been an enterprise, because the motivation to settle is what? I know that, in fact, I'm somehow liable and I would like to avoid full liability. That's why someone usually settles. So she's saying, being that they settled with this young lady, they honestly are insinuating that they were an enterprise. And that's relevant. So government will be allowed to discuss this 16-year-old girl who allegedly had an encounter with R. Kelly. And they will also be allowed to discuss the fact that R. Kelly then allegedly paid her a settlement, not to discuss what happened. Okay. Anything on that, Diva?
These are girls that I don't even know who to connect this one with. So a lot of these girls are girls we don't know.
Very, very interesting, because Diva and her people are on it. So for them to say that they're not even aware of who this is, that just goes to show you that the government had a lot up their sleeve. All right, next evidence. Well, actually, our next thing is a teaching moment, not even evidence. All right, so we're here on 19, and we're here at line 3. The court says, And I should have said that at the beginning, that there are many instances that I've ruled that are admissible that will require a curative instruction should the parties request it. Okay, so here's a teaching moment. What Judge Donnelly is saying is, listen, yes, I am ruling a lot of these pieces of evidence to be admissible, and yes, they will be discussed at the trial. But if it harms either party, they can request that I have a conversation with the jury in which I make sure that it does not do an enormous amount of illegal or unnecessary harm. So what she really means is, let's say, for example, with a lot of these Jane Does, right? The defense attorneys could and probably should will request that Judge Donnelly have a conversation with the jury in which she says, now, ladies and gentlemen of the jury, when you hear about these Jane Does, you are not to consider whether or not R. Kelly actually had intimacy with them. Don't consider that. What you should be considering is their testimony regarding their interaction with other members of R. Kelly's team and the allegation that those members then brought them to R. Kelly. That is it, right? So that's just an example of a type of curative instruction that could be provided. So defense attorneys probably will do that. They probably will say, Judge Donnelly, for some of these accusations, we need you to explain to the jury what they're considering it for. Okay?
Okay, so they're allowed to only speak about their experience with the enterprise, not about the sexual experiences. Correct?
Absolutely. That is correct. And okay. I am going to go ahead and mod some people in the chat.
Yeah.
Because, unfortunately, I see that there are some things going on in the chat that, you know what, maybe not necessary. So what I'm going to do is go ahead and mod, and let's have a quick little combo. This is a space where we are unbiased, right? So I do not come onto this space and express my personal opinions. I come onto this space, I read transcripts, I explain the law. If you do not like what the law is, I'm sorry. But that is not my personal opinion. That is the law. And you are open to have a personal opinion that's different than the law, right? That's totally cool. But when you're in the chat, be respectful to everyone in the chat. And that's for both sides, right? Everyone be respectful to each other. Because at the end of the day, you guys, we are having a conversation about what is happening to someone else. You are not Kelly, okay? So do not find yourself so involved with his life that you're being disrespectful to other people. It's just not a good look, okay?
Thank you, guys. Right. Mod me, Miss Esquire.
Yeah. So I modded Take R. Kelly.
And Blade
as well.
Mod Blade.
I just modded you, Diva.
Thank you.
And then I modded Blade as well. So we have some mods. So you can have an opinion that's different than maybe most of the people in the chat. That's cool. But do it respectfully, because
no disrespect. No disrespect. Okay? No disrespect.
All righty. And as Michelle Jordan said, please don't take it personal. I mean, my goodness, R. Kelly is the one on trial, not you. Okay. All righty. Let's get back.
A bunch of heathens in here. Hello.
We are going to find the next evidence. So here we are on page 27, but we're going to roll it back to page 26 because we want to have a conversation about what this evidence is before we go into it, okay? So here we are on page 26, line 10. Mr. Farinella says, Your Honor, also just to ensure for the record, we have not been given any specific information as to the various employees and witnesses that have been identified in terms of specific references as to who they are. And the court says, have you given the names of who employee number 1 is? The government responds, we have provided 3,500 material for each of these employees, which include their first and last names. The court then goes on to say it might not be a bad idea, just given the volume of information, to give them a list. Okay? The government agrees to that. The court then goes on to say, if it's not clear, that is admissible and relevant evidence. Pause.
Okay.
Donnelly is saying that any argument that the government wants to make about employees of R. Kelly's who are allegedly involved in this enterprise is relevant.
Ooh.
Now, we know defense team tried to argue that certain conversations about certain employees aren't relevant because they're disgruntled, but that's not relevance, right? So let's have a quick teaching moment.
Right.
Whether or not a piece of evidence is relevant is whether or not it speaks to a material, and material means important, fact in the case. Right. So when they're talking about, this person is disgruntled or this person had quote unquote beef with R. Kelly, that doesn't make the person's testimony irrelevant. That just means that the jury should be told to consider that when they're weighing the credibility of the witness. We talk about credibility a lot. So your history with someone is something that could make you either a more credible witness or a less credible witness. But it does not make your testimony irrelevant.
So that's being put in. Don't get mad.
That's being brought in. Again, you guys don't come on. This is a transcript. Judge Donnelly said this. Getting upset at people in the chat about what Judge Donnelly said is asinine. Okay. All right. So let's move on to page 28. So now we're talking about more evidence. So actually, we have to run it back to page 27. And start here at line 16. The evidence, according to the government, is that Mr. Kelly began a sexual relationship with Jane Doe number 16 when she was either 16 or 17, and that she stayed with him until 2017. Okay, so that's the evidence. She then goes on to say, this is direct evidence of the enterprise's means and methods, and particularly over that long period of time. So it is surely relevant. And it is surely admissible for the purpose of being direct evidence. So again, we have yet another Jane Doe. We have that she had a long-standing relationship with R. Kelly, allegedly. Yeah. And we have the defense team trying to say it's not relevant. And we have Judge Donnelly saying, well, actually, if she was with him over this period of time, she had to have interacted with other quote-unquote members of his team, which makes it relevant to whether or not there was an enterprise.
Right, so, the handlers, right, the handlers.
So they get to bring that in as well, okay? And if you're noticing that we've seen a lot of pink thus far, yeah, that's right. Okay, so then she goes on to say that this evidence, her same language, is not more inflammatory than the charges. So what she's saying is, again, it's not more prejudicial than the actual charges. They're accusing him of having an enterprise which took intimate advantage of young women, and this young woman is alleging that he took advantage of her. It's par the course for the charges, is what Judge Donnelly is saying. Diva, do you have anything you'd like to add before I keep moving?
So the charges are more offensive than the actual crime itself?
No, she's saying that these allegations, this testimony, is not more prejudicial or more inflammatory than the actual charges. So she's saying the testimony will just be what's already in the indictment, right? It's the testimony.
Right.
What you're already charging him with. So you're not saying anything that would be any more horrible than what he's already being charged.
Than what he's facing. Right. Got it. Okay. Auntie is not playing. She is not. She's like, listen, y'all got to understand that we're playing connect the puzzles. And if this puzzle belongs to this other side and it connects, it's got to go in because it fits.
Exactly. And she is really not. She is on it. And for those of you who think that thus far she's behaved in a biased manner, I assure you she has not. She has not. Everything she's saying is spot on legally. When you have a case, when you have a case with allegations of intimate crime, all of these things are going to be relevant. When you have a case that's alleging that there was an enterprise of human trafficking, and all of these things are relevant. So she's not being biased at all. She's right on point with these rulings, in my humble opinion. All right, let's keep it rolling. We're on page 20.
Excuse me 1 second, Miss Esquire, if you don't mind me addressing a question in the chat.
Go ahead.
Lovely Dip Tea. You said it says, assuming that Jane Doe 16 testifies as the government represents. Yes, they're saying if she does, assuming that she will. Listen, the trial's about to start. Some people do back out. That's why she's saying that. That doesn't mean that the person's not testifying. Is that correct, Ms. Esquire?
That is correct. So they have to say, especially from the court's perspective, Judge Donnelly has to say, assuming that she testifies, assuming that she said, because of course we don't know. She may ultimately not testify, right? These rulings are whether or not she would be allowed to testify. That is what Judge Donnelly is deciding.
Exactly. That's it. That's all.
That's it. That's all. She can't control whether or not Jane Doe actually does testify. So you never know. Okay. All righty. So we are now on page 29, but of course we want to run it back probably to 28 just so we are sure of exactly what is being discussed. All right. So they go into Jane Doe 16 and her testimony. And they do mention that she may not testify here towards the bottom of the page, right? So it's possible that she won't. Then they go in to talk about Jane Doe number 16 and Jane Doe number 17. Okay, so let's talk about this little section here. Okay, so let's start with here. I'm not saying that. I'm saying even if she does not testify, I think it is still relevant and admissible because Jane Doe number 5 firsthand saw and heard what was going on, and it was relevant. It was one of the ways in which the defendant maintained control over Jane Doe number 5, was showing her what would happen to her if she violated a rule in the same way that she had seen Jane Doe number 16 or Jane Doe number 17 violate that rule. So then the court goes on to say, as long as it is non-hearsay, it is admissible. So what is the government wants to present evidence that there was a Jane Doe who broke an alleged rule of R. Kelly's, and that her punishment for breaking that rule was in some way shown to other Jane Does to control them, right? A sort of, if you do what she did, this could happen to you kind of thing.
I think we know who those girls are.
Some of you who are more involved in the sector you may in fact be able to make some type of educated guess as to who those girls are. Now, the reason that it is relevant, again, like the judge said, as long as it's not hearsay. So as long as these Jane Does are saying, I saw with my own eyes this or that, it's admissible. And the reason why it is admissible, again, is because it all goes back to the racketeering and the enterprise. Why? Because there is always someone involved. When you have R. Kelly is usually in these allegations, not himself showing girls what happened to other girls, right? R. Kelly is usually not himself doing all of these things and carrying all. It's usually someone he told to do it. So Judge Donnelly is saying all of this is relevant because more than likely, whatever this punishment was, whoever filmed this punishment, whoever observed, whoever, they're all a part of the enterprise.
Allegedly. Right. Being that they were actually in the room recording it, they're complicit to the crime. And they were under direction of him to sit there and record it, aiding and abetting.
Precisely. And so that's the allegation. And so Judge Donnelly is saying that's relevant. That's pretty much her ruling. Okay. So now let's go on to page 30. Okay. So now we have another teaching moment. She then says again, usually a defendant's prior sexual conduct is not relevant, but there is an exception under which it could be relevant. However, that still has to pass through Rule 403. So Judge Donnelly is saying, listen, a lot of these pieces of evidence meet the exception where, yes, we're going to be discussing R. Kelly's past sexual conduct, but it still has to be more probative than it is prejudicial. Still has to meet that standard.
Right.
Okay. Now, towards the end here, again, she clarifies, she says, everything that I've ruled to be admissible is because it is direct evidence of the enterprise. So she doesn't leave any room for you wondering, well, why is this? She's very clear. because it is direct evidence of there being a criminal enterprise.
Right. Everything links. The pieces of the puzzle go together.
Everything is connected. And again, make no mistake, all of these allegations are not that R. Kelly, almost all of them say that R. Kelly told someone to do something. That is the definition of an enterprise.
Right.
That's the definition of an enterprise. One person telling someone to do something, they then are in concert committing an illegal activity. Enterprise. Okay.
So in my opinion, I have a question. In your opinion, I meant to say, in your opinion,
yes,
do you think that throwing a racketeering together, a RICO together for him was a good thing to make something stick?
So here is what I think, in my humble opinion, right?
Yes,
I think that if the prosecution were to try to form a case in which they only talked about his contact with these girls and they did not discuss this alleged enterprise, they would have too many holes in their case, right? Because they would have a case where they're presenting girls being punished and girls being filmed. And any person with a brain is going to say, well, who filmed? Okay, so who gave her that cell phone? So how did she get from the concert to his house? So how did all of these questions are questions that naturally flow. So I think their case would have had way too many holes in it if they did not present the enterprise.
Wow. So doing throwing a RICO charge was a good thing to do to put R. Kelly in jail for abusing the girls.
I think so. I think that it made a stronger case. And what I also think is, and although the government will probably not openly admit this, it sends a stronger message, because when you have men who are in power, a lot of times they use that power, right? So again, whenever you have like a rapper or a singer or whatever, you guys have heard all these stories, right? We're post the video girl days. So we know that LL Cool J doesn't walk up to a girl and say, hi, how are you? We know he sends somebody. We know Trey Songz doesn't walk up to a girl and say, hey, how are you? He sends somebody. So the government is sending a message to all of these powerful men. Watch yourself, because if you start to send people to do things that are illegal, you're forming an enterprise.
Exactly. Thank you for that.
You're welcome. I'm going to take a quick look at the chat, see if there's anything that I don't see any questions. I just see a lot of comments. All right. Hello to Nicole. All right. I don't see. And OCOV, I already gave you a shout out. Hi to Rocky.
Shouting out once again, OCOV in the building. What's up, guys?
Hello. How are y'all? Thank you for being so supportive. All right. Let's talk.
Hello, family of Miss Esquire as well that's in the chat.
Oh, absolutely. Absolutely. A lot of my OGs, as I now call them, are here today. Oh, my goodness. My dog is barking. I don't know why. Anyway. Okay. So we're going
to check on that if you can. That's fine.
No, he's good. He tends to, he sees a shadow in the window. He barks. You know how dogs are. So now we're getting into some blue. So for those of you who have just joined us, pink highlights are rulings that were in favor of the government. Blue highlights are rulings that were in favor of the defense team. And then yellow is just something that we should discuss for our own edification. So here, after 30 plus pages of the transcript, we've gotten into something that was ruled in the defense's favor.
Oh, wow. Wow. Look at guys. You just got to win. You see? R. Kelly got one little win.
So we're going to take it back. We're going to roll it back to page 33, right? So we can know exactly what we're discussing. Okay, so here we go. Ms. Getty says, the government anticipates that as a part of Jane Doe No. 1's direct examination, we would also elicit the allegation or the fact that he admits that in 2008, he had access to a juror. And the defendant's response to that, the thing we are far more interested in introducing, the fact of the 2002 charge and that the defendant was on trial for was under indictment for such a long period of time and was ultimately acquitted in 2008. The court then says, what's the relevance of that? I'm not inclined to permit it, by the way. She then goes on to say, I don't see an admissible purpose for that. Generally, the fact that someone was acquitted of a crime you would not be permitted to inquire into that. And I don't really see a good reason to permit it here. Obviously, if something comes out during the trial, that again, doors can be opened all the time, but I don't think that's admissible. So I'm not going to permit that.
Okay, break that down for us, girl.
All right. So here is what just happened. So here the prosecution said, Judge, he was previously acquitted, and there were murmurs that the jurors were tampered with. So we want to be able to discuss that trial. And the judge said, no, when you are acquitted of a crime, it's not fair for your acquittal to be brought up when you're being accused of a totally different crime. No, that's not admissible. But at the very end there, she says, doors can be opened all the time.
Right.
So in the legal world, whenever a judge says, well, if someone opens the door, this is what they mean. If someone on the defense end, whether that be R. Kelly or one of his witnesses or one of his attorneys, mentions that previous trial or alludes to that previous trial, they have opened the door. So that's what Judge Donnelly means. So she's saying, prosecution, you can't bring that up. But if they open the door, you're more than welcome to walk through.
They're gonna kick in the door like Biggie. It's the Brooklyn way.
So that's what that means. All right. So, I mean, any thoughts on that, Diva? Let me actually go back up to it.
That's crazy. So she can just like she said, we're gonna leave that out. That's not importance. But if need be, something creaks open and leaks in, we got to throw that in.
Right. He's saying if his team brings it up in any way, then you're welcome to talk about it, but you can't bring it up.
Ah, got it. Okay.
That's what she's saying. Okay.
So the government can, but the government can't, the prosecution can't, but the defense can.
Yes. And if the defense does, now they've opened the door for the prosecution. So the policy behind it is, if you are found not guilty of something, the government should not be allowed to talk about something that you were found not guilty of. You were acquitted, right? But if you get on the stand and you start saying, well, they tried to get me on this back in 2001 and I got acquitted. Well, then now the government should be allowed to talk about it. You're the one who brought it up.
Right. Okay.
That's what she's saying. Does that make sense?
Yes, ma'am. It sure does. You got that, guys?
Everyone in the chat got that?
Yeah. We got some slow bus people. We got some slow bus people in the background, though. They way in the back.
Alrighty, so now we're still on page 34 still, and now we're down towards the end of this page. And we have the court saying the next category of evidence has to do with audio recordings that depict the defendant yelling and physically assaulting women. And those are clearly admissible as direct evidence of the methods used to perpetuate the enterprise. And it is direct evidence of the defendant participating in it.
Okay, so that evidence where he recorded cursing the girls out and threatening to abuse them will be admissible.
Precisely. And the judge is saying it is admissible because it proves that he was involved in the enterprise, and it proves that there was an enterprise because the enterprise had methods by which it punished people. So going back to what Diva said about the mafia and gangs and things like that, when you do something wrong in the mafia, there's a punishment, right? They take a finger, They take a toe, they bust your kneecaps, whatever. So every enterprise has punishments for when you break a rule. So that is why it's relevant, because Judge Donnelly is saying, well, this tends to show that there was an enterprise and these girls were being punished for breaking one of the enterprise rules.
Auntie, you go, Auntie.
Listen, Judge Donnelly is on it. She's on it, and I think she's fair.
Really is.
All right. So now we are going all the way to page 39. Now, this is in regards to some text messages. So Judge Donnelly was talking about some of the text messages that were exchanged allegedly between R. Kelly and some of the Jane Does. And she said specifically, it is not hearsay. If she says she wrote it and what the reason was, it is really not hearsay. It's evidence of fact. So that's her ruling regarding all of these text messages. If they can get someone, any of these Jane Does, to say, yes, that is me, yes, I sent that text, then Judge Donnelly will decide that it's admissible, that it's not hearsay. But it will be hearsay if they're trying to enter it in through some other witness.
Okay, so because there was also text messages between the employees, and there was text messages between one of the Jane Does and her parent.
Right,
so
right.
Yeah, which ones are those?
So those may be admissible. And again, that's another thing that the defense may ask for a curative instruction on, right? So Mr. Farinella may say, okay, Judge Donnelly, we know that you're letting in these text messages. We would like you to explain to the jury that these messages are not necessarily to prove that something happened. They're more so to prove that there was an enterprise. And so Judge Donnelly, and this is an example, by the way.
She's letting that in too. She's letting that in too.
No, I'm just giving an example of what Mr. Farinella could ask for.
Oh, okay.
And then Judge Donnelly's instruction could be, ladies and gentlemen of the jury, the text messages that you just heard about testimony in regards to, you are not to consider that testimony for whether what was discussed actually happened. You are to only consider that testimony to establish that there was a concerted effort and communication going on between these parties.
Okay, so they have to prove that the conversation really happened.
Right. They have to have someone who can authenticate that conversation. Because I think we discussed this on your channel before when we talked about text messages. So people who have never been to Diva's channel, let me break it down for you really quickly. When you have a text going from one cell phone to another, any defense attorney worth $1 knows that the best argument to make is, yes, that text came from my client's phone, but he didn't send it. Or yes, that call came from my client's phone, but she didn't make that call. So that is why you have to have a witness to authenticate, because just because a message was sent from one person's phone to another person's phone is not going to stand up in court for you to say that that message definitely came from that person. Someone can always take your phone and start sending messages.
Okay, yeah, got it.
So that's all Judge Donnelly is saying. She's saying, give me the person who actually sent these messages, have her say she sent them, and then you're welcome to talk about them. That's it.
Okay.
All right, so I think we, I thought we were rounding it out, but we got a little bit more. Let's see. All right, so page 46 here. Now, this is another good moment. So Judge Donnelly is about to discuss whether or not the defense can go into the mental health and the mental history of these Jane Does.
Okay.
There has been a lot of hubbub about which Jane Doe has depression, which Jane Doe is bipolar,
right?
Which Jane Doe has a therapist, all this other stuff. So Judge Donnelly says this. With respect to one of the witnesses, I think it would be decidedly unhelpful to the defense just as a practical matter, given the nature of that evidence. So unless there's a showing that a witness's mental health affects the witness's ability to perceive and recall, that evidence is inadmissible.
Okay. I'm sorry.
No, you're fine. You're fine. Did you have a statement to make before I break it down?
Yeah. So, in other words, they can't talk about that. That's not relevant to the case because
precisely
her trauma is her trauma.
Precisely. Right? So in general, they cannot talk about, like I said, which Jane Doe is bipolar allegedly, which Jane Doe is allegedly, depressed. They cannot talk about that in general unless they can prove that. So that's what she means by a showing, right? Unless they can prove that whatever this mental health issue is, it's affecting the memory of that witness. And so they're not reliable.
The memory.
The only way they're going to be able to get that in.
So do you think that in this trial they will have health professionals testify about these girls health, mental health issues, or they're saying they're not going to let it in at all?
So what Judge Donnelly is saying is it can only be let in, like I said, if there is a showing that it is affecting their memory. It's affecting their ability to actually recollect what happened.
To remember what happened. Okay, got it.
So the defense team may present the defense team may try to present some sort of professional who presents that showing, right? So let's say, for example, being allegedly bipolar. Maybe defense counsel has some expert that they want to present who says that, you know, when bipolar people are in mania, they don't remember what they did.
Right. They block it out.
Right. Now you're taking a step towards opening that door if they can prove that this Jane Doe is allegedly bipolar.
Yeah, and I was talking about that the other day on my channel as well, that, you know, a lot of victims of some type of assault, we choose to block it out and lose memory. So when we show up on trial or we're going to the police about things, we don't all remember every moment, every word, the place, what it looked like, the time. You know, it's when you're shooken up, you're shooken up. It's hard for a woman to stand on trial and remember every little incident. And then with the attorneys cross-examining you and trying to attack you, you know, it brings you to a very bad place. You know, I feel bad for these girls. That's all I gotta say.
So I'm gonna hop back in the chat and say hello to some people and address a few comments. So hello to Lovey Dip T. I see a comment here. Hello to Flawless Beauty. I see Lovey Dip T said teenage young women are not children. I have to address this comment because, again, YouTube has terms and conditions. Okay. So by law, an adult is 18 and older. That's the general, and that's also what YouTube recognizes as adulthood, by the way. So if you're referring to someone who's under the age of 18, please be mindful of your comments. I don't want my video having any issues with YouTube because we're saying that, you know, it's okay and they're not children. So let's be mindful.
Thank you. Can you please delete that comment?
Hello to Lisa Marie. Lisa Marie, thank you so much for the compliment. That's so sweet of you. Hello to Nicole. And I think I've gotten and again, another shout out to the OCOV fam. All right, so let's hop back into the transcript. So let's see, we're here on page 47. So Judge Donnelly also addressed this back and forth about the parents. Now, there has been a lot of hubbub about these parents. A lot of people saying that the parents should also be charged. A lot of people saying that the parents pretty much handed over their daughters allegedly and this and that. And I think I've said this on Diva's channel, so I'm going to say it again. The parents are not on trial. So having a conversation about what the parents could or could not have done is not relevant to this trial, right? So that's the first thing. And the funny thing is, I think Judge Donnelly says the exact same thing, right? That is not relevant to this trial. But now here is the next part. And someone in the chat said this, and I thought, we have a lawyer-minded person in the chat.
Okay.
Anyone who is alleging that they are a supporter of R. Kelly and they are arguing about parents being charged, be careful what you're doing. You are hurting R. Kelly. I'm going to say it one more time. If you are saying that you are an R. Kelly supporter and you are arguing about parents being charged, you are hurting R. Kelly. You are not helping him because you are saying, yes, these girls were abused. That's what you're saying. You're saying, well, the parents should be charged too. Yeah, he did it. So charge the parents too. You are saying R. Kelly did this. Do you realize that? You're saying
no, they really don't.
So if you're an R. Kelly supporter, be careful what you're saying online about the parents and everybody else involved, because you could be confirming the allegations because you're worried about someone who's not on trial right now. This is the trial of R. Kelly. Let's focus, people. Let's lock it in. Okay.
Right.
So here's what Judge Donnelly said about the parents. unless the witness participated in it, then, certainly cross-examine them about that. But just a general question about what the parents were doing, in a case with allegations like this, and the parents couldn't consent to the behavior that's alleged, so it's not really relevant. Pause. If a person is not of the legal age of consent to have intimacy, no one can consent for them. So if someone is only 14 years old and some person wants to have contact with them, their mom or dad can't say, here you go, you can do it, and now it's okay. That's not how it works. It's illegal.
Right.
That's it. There's no one who can give consent. So Judge Donnelly is explaining that. She's saying it's irrelevant because regardless of what you're alleging the parents did, the parents can't give you consent to have a legal contact with their child.
No, the best part is when R. Kelly has the Gayle King interview and he says, but the parents sold them to me.
Oh my goodness. No comment. Judge Donnelly then goes on to say, so that's not going to be admissible. Just generally talking about the parents. But if the allegation, which is what I understand it to be, is that the particular Jane Doe witnesses were a part of this plan, then you can ask them about that. So here's what she said. If your allegation is that the parents were a part of the enterprise, you can ask them about that. But then again, remember my initial comment, that's a trap. That's a trap. Because if you're questioning the parents about them being a part of the enterprise, you're admitting there's an enterprise.
Wepa.
So that doesn't even make any sense, okay? But anyway, she said that's not admissible. She said absolutely not. That was her ruling on that.
Okay. So
and,
talking about the parents.
Yeah, I think
unless they were part of the enterprise.
Right. And so we are actually at the end of that transcript. So listen, I'm going to have Diva give some insight. I'm going to take some questions. And then I think we'll hang out a little bit longer because I wanted to watch this video with R. Kelly's former attorney discussing this case and discussing jury selection. So,
oh, yeah, let's do that. Yes.
Diva, do you have anything you'd like to share before I take some questions and we move on to the video?
Convict R. Kelly 2021.
Diva Divine Light's thoughts and opinions, though she is a wonderful person, are not necessarily the thoughts and opinions of Phyliciacpearson Esquire, nor Empowered Esquire TV. All right, let's take it on to the video, shall we?
Yes, ma'am.
My tab, and let me make sure I click share audio. Awesome, here we are. Let me take it from the beginning. I was watching it a little earlier.
Welcome back to BNC Live. I'm Tishani Whitlow. A judge is questioning potential jurors today for the trial against R. Kelly. Yesterday, dozens of people were questioned and 13 were dismissed. The jurors are expected to hear testimony from Kelly's alleged victims as prosecutors work to show a pattern of abuse by the 54-year-old singer. Kelly has pleaded not guilty to all the charges against him. And to continue the conversation about R. Kelly's trial and bringing back attorney Michael Leonard to the conversation about the trial. So we finished in the last block, we were discussing the jury. Is the jury ultimately being sequestered where they can't watch any TV, no radio, no nothing, to try to figure out, if they don't know who Kelly is, to learn more about him?
No, but they'll be admonished, just like in any other trial, that they're to do absolutely nothing on their own in terms of reading about the case, reading about Mr. Kelly, reading about witnesses, and all that sort of inquiry, which is typical in a federal trial. And that's difficult to monitor, and that usually is an issue that if you find out about it, usually after the fact. So they'll be given admonishments every day about not doing any independent evaluation, any Google searches, any social media. And clearly the world will be watching, because if anyone were to post who is a member of the jury, that would be something that would be quickly found out. But in terms of their ability to conduct independent research, that's always a possibility. Someone can always do it. And you just hope that the judge's admonishments will keep them from that temptation.
All right, Attorney Leonard, Monday, Kelly's attorneys asked the judge to throw out a charge against him, alleging that he gave herpes to some of his accusers. Can you explain that charge and why there may be grounds to actually have it thrown out?
Sure. So, as you know, as we've talked about previously, this is a RICO, R-I-C-O case, which the core allegations are that Mr. Kelly was the head, sort of like the kingpin of a criminal enterprise. And so in support of that criminal enterprise, the government is relying upon different underlying predicate acts to try to prove that this enterprise, or so-called enterprise, committed all these criminal acts in furtherance of the enterprise, that was part of its purpose. And so some of the allegations relate to Mr. Kelly allegedly violating laws by engaging in sexual intercourse or relationships with people when he knew he already had herpes, which under some state laws could be a crime. And in terms of the most recent motion filed, the defense did file a motion to dismiss. And it's basically making the argument that some of these issues and allegations are time barred, meaning that the government is bringing them forward too late. So it is unusual to bring a motion to dismiss on the very eve of trial, and that would probably suggest that it's not going to get granted by the court. However, you're also, as we talked about earlier, you're paving the way for an appeal. You're preserving these issues that you think might be valid legal issues for purposes of appeal, because if you didn't raise them now, they may be waived. So that's part of the strategy of this very late filed motion to dismiss. It's trying to make sure that these various issues that might be purely legal in nature are preserved and aren't waived.
All right, Attorney Leonard, with all your years of experience, can you talk about what we can expect as this trial moves forward?
Well, sure. This is unique, of course, because it's a very public case where there's been much said about Mr. Kelly for an awful long time. Much has been reported about him. We have the docuseries. So going into the trial, there's the big concern on the defense side that you're getting people who already have made predeterminations about Mr. Kelly and the allegations. So in selecting the jury, which is not unlike most federal cases, you're looking to try to get people who can be open-minded, who can actually apply the law. And that's difficult, but in a case like this, which is very technical, a RICO case, you could find jurors that potentially what you're looking for is people who can be open-minded, hear this evidence, and then apply the particular instructions that Judge Donnelly is going to give at the end of the case, which is hard to do because sometimes the sympathy or the nature of the allegations outweigh the jury sticking to the instructions. So from the get-go, from jury selection through the opening argument, which will be next week, through the questioning of the witness, the defense is going to really attempt to not only call into question the credibility of some of the witnesses and the lack of corroboration of some of their stories, but broadly speaking, they have to also be concerned about trying to prevail by showing that there is no enterprise. There's no enterprise. This is a band. This is a guy who is a leader of a band. It's nothing like a mob boss. It's nothing like a drug kingpin. They can still argue, he may have done some things wrong, but it doesn't constitute a legal enterprise.
And
so
speaking
that's
of
going to
that,
be one of the biggest focus of their defenses.
Attorney Leonard, I hate to cut you off. I just want to move the interview forward because we're running out of time. How many accusers are we talking about in New York alone? Because he still has other charges in 2 other states.
Well, so in this case, the government will present probably 10 or 12 witnesses who are part of the charged allegations, meaning
So a
that
dozen
they're claiming
women. A dozen women.
But there'll be more than that because they're also going to put on people whose conduct didn't relate to a specific charge, but the government nonetheless wants to introduce the evidence to show the enterprise or to show a pattern. So you may have as many as 20 or more victims testifying in this case.
Okay. And I guess my last question for you is, how is Kelly doing? I mean, he's been behind bars for 2 years at this point. Is there a possibility that he will see the light of day?
Sure. I mean, obviously, if he's victorious in this case, then there'll be a substantial opportunity for him to be on bond, right? So that's the first step. But clearly, he's struggling. Not only was he detained for a long period of time prior to trial, but unfortunately, he was detained in one of the worst time periods to be detained. The COVID pandemic has made it extremely difficult on everybody who was imprisoned, jailed prior to trial in the Chicago MCC, as well as across the country. You're basically in segregation, lockdown type facilities, fearing you're going to get COVID, and essentially limit it to a couple hours a week outside your cell with no recreation. So he clearly has suffered, and there's things that came up recently that his counsel has mentioned in terms of weight loss. Obviously, your mental health is an issue when you're in prison, when you're jailed that long. So he's clearly struggled and been jailed in one of the worst times you could possibly be. So actually, the movement he's getting, the opportunity he's getting to meet with his counsel and all that sort of stuff, it's got to be incredibly refreshing because his movement was so incredibly limited prior to trial.
And I know that you were no longer representing him because you asked the judge to be removed from the trial. But you seem very optimistic that he could get bonded out, even though he was denied previously, and he still faces 2 additional trials. We are out of time, so if you can answer briefly.
Yeah. Let's not get ahead of ourselves. He's got to win this case, and clearly then the issue of bond will be back on the table. So we're many, many weeks away from that. This case will probably take 6 to 8 weeks to even talking about him being bonded out after this case.
Got it. Attorney Leonard, always a pleasure. Thank you so much for taking the time out to talk with us.
Wow. Someone needs to be accountable for this.
Can we just say that I can't stand autoplay? So there you have it, right? You've heard from one of R. Kelly's former attorneys about what he thinks could happen during this trial. You've also heard about jury sequestration. And what you've heard about that I have been kind of prefacing here with you is CYA. So when he talks about all these motions being filed and motions to dismiss and this and that, everybody don't get in this big hubbub. Every time the defense files a motion to dismiss, I see videos online saying case is going to get dismissed. R. Kelly's free. What are you talking about? Everybody calm down. As this attorney just explained, it's CYA. And if you don't know what that means, Google it, right? It is the attorneys covering themselves and preserving issues for a potential appeal. They do not actually think that this case is going to be dismissed this late in the game. Now, as for the jury, you hear that they will be, told, please stay off of the internet. Please do not discuss this case. The typical jury instructions, right? And of course, it is really on the honor code for them to follow those instructions. There really isn't anyone by their side 24/7, to report if they end up going on the internet on their phone, as Stephanie Collins said. Let me hop back in the chat. Hi, PETA. Hi, Stephanie Collins. There's somebody else I know I missed. Wings, I think is the name. Wing. Yeah, Wings.
Rocking with the truth. What's up?
B Buccaneer, rocking with the truth. Yes. Hello to everyone. We're actually going to go ahead and start closing it down. If there isn't any questions. So Diva, do you have anything you'd like to add?
Yeah. It's Farinella was saying that the trial looks like it's going to last 8 to 6 weeks, but in the motion, Judge Donnelly had mentioned 4 weeks. What do you think about that?
So what's happening is that Judge Donnelly is saying, let's get a move on it. She's saying, listen, I want to make this happen. Let's go 4 weeks. She plans on running a tight ship. But I'm going to tell you all, in my humble opinion, this is a lot of witnesses and a lot of counts on this indictment for 4 weeks. Honestly, I think even 6 to 8 weeks is ambitious, honestly. But I think that 8 weeks is really the most doable time that we've heard.
Wow.
It seems like Judge Donnelly is going to be on it. She's going to be like, let's go. Come on, next witness, get down, get out of here.
Right. Keep moving.
Right. That's what it sounds like.
That's crazy. And this is going to be this is going to be hard for him to fight, guys. Like, honestly. There's a lot of evidence that they've piled against him, and they're continuing to pile as they go along, because even with this case being presented at trial, it's still open. So, Ms. Esquire, can they still present new evidence with the trial going on?
So if they were to present totally new evidence at this point, that would be something that would first have to have the permission of Judge Donnelly, because I assure you that at this point, if it's something that was never, ever, ever prefaced or disclosed before, Farinella and everyone else is going to lose their mind. They're going to say, oh my goodness, see, we were right. You've been withholding evidence. So whatever it is that anyone plans on presenting at this point, it better have been disclosed unless they're going to Judge Donnelly first.
So would they be able to present new witnesses?
Usually not, unless, remember we talked about certain decisions that Judge Donnelly made that were kind of if this, then that. So that's the window by which you may get new witnesses, right? So let's say maybe they present an expert who proves that Jane Doe such and such has some mental issue that is a problem, right? The testimony of that expert might be let in as, you know, technically an additional witness, but for the purpose of setting the stage for them to talk about Jane Doe's mental health.
Okay. Thank you again, Miss Esquire. We love you. Thank you so much for having me on your platform. Guys, if anybody knows my handle to my YouTube page, please drop it in the link. That would be nice. Thank you. Oh, Miss Esquire. It would have to be a moderator. I believe it has to be a moderator. So if one of the mods can drop the link, you can follow my channel at Diva Divine Light. I talk about the case. And we also have Esquire come over there. So you guys who are Miss Esquire's family, you can always check her out over there. And hang out with me too, because I'm definitely in the R. Kelly sector, guys. And thank you, Miss Esquire, again. I love you so much for your knowledge.
Absolutely. I cannot believe that I sit here. I wanted to put your name up. And of course, I have to put Diva Divine Light. Oh, and I did it again. It's autocorrect. My computer.
I know. That is so horrible. I hate it on my phone.
You guys, shoot. It's Diva Divine Light. You get it. I posted the link to one of her videos in the very beginning.
Oh, thank you, KKC.
Right. So if you just scroll all the way up, you will see it. KKC. Thank you, KKC. Hi, KKC. Thanks for always being in the building and being so helpful. Hello to Yada. And I think we've got a hello to everyone. And listen, you guys, this has been a long one. We don't usually go this long, but we needed to make sure that this was thoroughly explained. There is so much misinformation going on. As we wrap it up, I just want to say, I've been disheartened by the misinformation and by a lot of people alleging that Judge Donnelly is doing things that she shouldn't be doing. And no, that's not what's happening. This case is proceeding as all cases like it proceed. Okay, there's no impropriety that we can see going on. So let's cease the misinformation and let's spread real information and be respectful to each other about our different personal opinions, right?
Yes, ma'am.
But anywho, this has been another episode of Empowered Esquire TV, A Real Lawyer Reacts. I've broken down the beginning stages of the R. Kelly trial. We will continue doing this because this trial will continue and we're going to have to keep up with it. We may bring Diva back.
Don't worry, girl. Yeah, I got you with all those transcripts. You already know.
However we do it. And we want to give a big thank you to our wonderful guest, Diva Divine Light, and to her fam in the chat. And also a big thank you to my subbies who came through today.
And all the R. Kelly supporters that are sitting in the bushes and that came in the chat. Thank you. Next time we do this, guys, just remember to be respectful to each other's opinions. Be respectful to the people that are on trial and the people that are victims in this case. And we can have a great dialogue and a peaceful chat, guys.
All righty. And you're welcome to everyone in the chat saying thank you. You're welcome. You're welcome. You're welcome, Joanne Reynolds and Service P and everyone.
You guys. You're welcome.
We are out.
Peace.